I'll just wait for the panelists to come online. They've all been very good and turned up in advance. So we've got a brilliant panel of people. Just make sure they can see their shiny faces. Brilliant. So welcome everybody. Welcome. I'm incredibly honoured. Well, I'm Alex Ruck, Keene. That's not interesting. But I'm incredibly honoured to chair this webinar, bringing together a really important, really interesting range of speakers to address just a really important set of issues. You can see the speakers there. You can see all bar one is a Twitter aficionado, so you can follow and stalk. No, please don't stalk. You can follow everybody on Twitter, and you can track down Mike Layton via LinkedIn. Because one of the things I don't want to do is waste lots of time in this introduction going through who everybody's going to be. I'm going to ask them to introduce themselves briefly as they speak, because we've just got this stellar range of people talking about an incredibly important range of topics. And I'm now going to go full Chris Whitty and ask Ian just to move on slide-wise, so we can see what we're going to be thinking about over the course of the next couple of hours. So Ian, yeah, brilliant. So that's me. I'm introducing very quickly. And then we're going to get Ian Brownhill thinking about the broad legal framework. And then Dr. Mike Layton moving into thinking about how capacity assessments might incorporate a risk or a history of offending. Then we're going to have this a sort of mini panel session thinking about this idea. Can you actually have capacity to commit a criminal offence? We're then going to have Caroline Liggins, solo, as it were, thinking about protections for people with mental health or capacity issues in the police station. Then we're going to have some really important data to try and actually track down thinking about the number of people with mental health problems / cognitive impairments in prison, and an approaches to sentencing. That's going to be from Gavin Dingwall and Jessica Gallagher. And then we're going to have Donna Phillips and Ben Troke thinking about medical treatment decisions for prisoners. And then we'll do our best to answer your questions at the end. I won't do any answering of questions. I will try and direct the questions to one of the stellar experts on the panel. So I'm really delighted that we've got so many people joining us. I'm really delighted we've got such a range of speakers. I don't want to say anything else other than to hand over to Ian, who's going to give us the kind of walkthrough of the broad legal framework. As Ian is a member of my chambers, I can tell him off if he's going over time. Everybody else is going to have to self-time. And if it looks like they're going slightly over time, I'm going to exercise chair's prerogative, unmute myself and suggest you draw to an end, but I shall be abrupt with Ian so everyone else gets the idea of how I might be as a chair. Off you go, Ian.
Thank you, everybody, and good afternoon and welcome. I am absolutely astonished and delighted by how many people are both here electronically, are coming along later, and how many people have asked to view this seminar afterwards. So thank you very much. For those of you who don't know me, I'm Ian Brownhill. I'm a barrister at 39 Essex Chambers, and I straddle two areas of law. The first area of law is in respect of mental capacity and mental health, and the second is in respect of criminal justice and prisons. And I work in this murky grey area between the two systems, and that murky grey area is what we're going to be exploring tonight, and trying the best we possibly can to try and draw together what the law actually is and how it works in practice. So thank you all for coming, and thank you for those of you who have joined us on the panel. And I wanted to start tonight with the 5 strange things that I've heard said in the Court of Protection and in the Administrative Court when it comes to issues around Ps who are offenders or Ps who might offend. And the first strange thing I have heard said more than once is that the Mental Capacity Act has nothing to do with people who offend. All of those people will be dealt with under the Mental Health Act. Well, that's simply not true. And that's obviously not been the case for at least the last 11 years. And hopefully I'll be able to explain why that is a little bit later. The other, perhaps more interesting from an ethical and legal perspective, is this statement. It's in P's best interest to offend and enter the forensic system That's the only way they will learn consequences. One of the very strange strands of argument we've had in certain cases is the idea that somebody will never learn unless they're allowed to make a mistake, but a mistake that is so catastrophic or so significant that they will end up in the criminal justice system. And we've had it argued in more than one case that without that taster of the criminal justice system, the person will never learn, and in particular, they will never learn consequences. I'm hoping that's something that Mike might mention a bit later. We then have a really practical point, but again, a point which people get confused about, which is the idea that the court of protection has to authorize everything when it comes to somebody who lacks capacity to make particular decisions for themselves. And a misunderstanding flows from one case and leads into this next quote. If you want to interview P as a suspect, you'll have to apply to the court of protection. Again, something we've heard in more than one case, and is something which is fundamentally not true. The next strange thing is one of my particular favourites, and I won't embarrass anybody because it actually features within a judgment. But one of the things argued in a particular case was that every prisoner throughout England and Wales has mental capacity to make every decision for themselves. Otherwise, they'd have been found not fit to plead, or they'd have been transferred to a secure mental health hospital under Section 47 of the Mental Health Act. And again, for reasons which hopefully Donna and Ben will explain later, that's simply not true. There's lots of decisions that prisoners have to make within prison, and there's lots of times when prisoners aren't able to make them because of a disorder of the functioning of the mind or brain. And then the last one is the one which a few of us are going to be talking about and touching upon throughout this afternoon. And that's the idea that P has the mental capacity to commit criminal offences and the mental capacity to be arrested. I'll say right now, up front, there is no such thing as the mental capacity to commit criminal offences, and there is no such thing as the mental capacity to be arrested. But I imagine that Mike and Caroline will explain why in a better way than I could. So I just want to start really with the Mental Health Act, because the Mental Health Act is effectively the source of some of the confusion when it comes to the Mental Capacity Act for Ps who offend or who might offend. Because people look at Section 2 of the Mental Health Act, and I've taken Section 2 here as an example. They look at the Mental Health Act and they go, it's straightforward. It says on the face of the Act what you can do or what you can't do when it comes to detaining someone. And within Section 2, subsection 2, you're told that you can detain a patient if they've got a mental disorder of a nature or degree which warrants the detention. And then in the subsection 2b, it says explicitly that that person is detained in the interest of their own health and safety, or with a view to the protection of other persons. And it will come as no surprise to most of you, if not all of you, that in terms of the Mental Capacity Act, the words public protection do not get mentioned at all. And this really is where one of the great confusions comes from when you find yourself dealing with a person who lacks capacity to make various decisions for themselves, but who ultimately is at risk of offending or who has previously offended. The basic question is, how do you incorporate that risk of offending or that history of offending? How do you incorporate it into the use of the Mental Capacity Act? And when you start looking at the Mental Capacity Act, you will see within the first section, within the principles, a general drive towards autonomy, the autonomy of P, and facilitating their decision making. I'm not going to go through the principles, but I am going to highlight some things that are important. And again, the first thing that's important is section 1.4. and the idea about how offending links to unwise decision making. And again, going back to my slight spoiler alert earlier, when it comes to there's no such thing as capacity to commit criminal offences. One of the things that you will find in a lot of the cases when it comes to people with disorders of the functioning of the mind or brain, and when it comes to their offending or their risk of offending, one of the things that we see quite often is a suggestion that they are essentially making unwise decisions. And people go, we're not going to have anything to do with this. This is all unwise decision making. And as we move through my slides, and as we move to hear speakers later this afternoon, I hope you'll reconsider that stance. But essentially, the next two principles are the ones where you look at them and you think, how possibly can the Mental Capacity Act be used for people who are at risk of offending or who have offended previously? Because Section 1.5 says that if a decision is being made on behalf of a person who lacks capacity, then the decision you make on their behalf has to be in their best interests. Section 1.5 doesn't start talking about wider societal concerns. It doesn't talk, like the Mental Health Act, about public protection. And then even more crucially, in Section 1.6, you're told whatever you do in respect of a decision you are making on behalf of P, you must do it in a way that is effectively the least restrictive option. So looking at those principles, comparing them to the Mental Health Act, how is it then that the concept of offending or the risk of offending finds its way into the use of the Mental Capacity Act? Now, I would suggest that essentially, if you think there's a case where you're in that grey, murky area between the risk of offending and the use of the Mental Capacity Act, you need to think about two fundamental questions. The first fundamental question is whether P's offending is linked to an incapacitous area of decision making. So we know the Court of Protection, the Mental Capacity Act, you don't go anywhere near them unless there's been a determination that somebody is unable to make a particular decision for themselves. And that will always include making sure that you're not interfering in someone who is making unwise decisions. If you get over that first hurdle, then you then get onto the second aspect. And the second aspect is a question, well, in respect of that risk of offending or that offending that has occurred, is it linked to an incapacitous area of decision making? If so, what is in P's best interest in that area? And from the outset, again, I'll make clear, despite what I'm saying to you this evening, and despite what we're going through in respect to the law, at the heart of all of this always must be what is in P's best interest, not what's in the commissioning public body's best interest, not in what the police's best interest, and certainly not what is in the public at large's best interest. Now, someone, when we started advertising this seminar, someone rightly and cleverly and correctly asked me, well, when you talk about lacking capacity to make decisions and in having a relationship to offending or the risk of offending, what types of case are you talking about? And the first three areas are the most prolific where we see that, certainly within the Court of Protection. So access to the internet, most of those types of cases we see involve people accessing illegal content online, accessing the dark web to purchase things they ought not to be allowed to purchase, or alternatively, people who are acting as trolls online and putting themselves at risk as a result of that. And so that's one of the areas of offending that comes through. Probably the most common is in respect of contact with others or support arrangements in the community. And just earlier today, I had a friend and a colleague phone me from another chambers to ask me about that very scenario. Often, we are looking at the scenario that P is going into the community. And when they go into the community, there is some temptation to offend. And those are the cases that are often looked at. And indeed, the DY case is the most recent example of that. And then the other area where it started to come through, both as P potentially being offender, but also P potentially being the victim of offending, is in respect of capacity to engage in sex. The other things that have come before the court have been perhaps smaller, more individual, less common interactions with the criminal justice system. So in 2020, we had the judicial review proceedings in respect of capacity to conduct parole proceedings in the EG case. And then going way back when, to 2010, the president did a case in respect of a person who was being interviewed as a victim of a crime. And in that case, the president said you had to consider the person's capacity to consent to that interview process. Now, I'll just spend 2 seconds just highlighting that case. That case does not say that the Court of Protection has to authorize somebody who lacks capacity to make a particular decision for themselves to be interviewed for a criminal offence. That case talks about when P is a victim of offending. And Caroline, a bit later this evening, will talk to you about what goes on in the police station. But one of the things that you have to remember in all of these cases is that in actual fact, there are some people who've already had their decision-making taken away from them. It doesn't matter about their functioning of their mind or brain, because essentially the law has already removed their decision-making ability. Now, those people or those particular decisions will naturally fall outside of the MCA because there's no decision for them to make. So the obvious example are people who are coming out of prison who have license conditions imposed upon them by the Secretary of State for Justice. The Goldsworthy case was actually about a man who had capacity to make decisions as to his residence and care. Putting that to one side for a moment is quite helpful because effectively it shows how license conditions work. So someone comes out of prison, the Secretary of State says where they live, the Secretary of State might say who they see. In certain cases, the Secretary of State will even say that that person has to access particular mental health, alcohol, or drugs treatment. So in those situations, P can't make a decision for themselves in any respect because the law allows the Secretary of State to decide where a person lives. And that's the same sometimes in bail condition cases. So sometimes the criminal court will impose bail conditions that says P has to live in a certain place. So if they say that P has to live in a certain place, P can't go there and make a decision for themselves to live elsewhere. Likewise, the Court of Protection or yourselves as decision maker, you can't decide that P would live in another place. And then finally, the other primary source of decision-making ability being taken away from P by the criminal courts is in respect to things like sexual harm prevention orders, and again, they're going to mention in DY, and other ancillary orders of the criminal court. So they might be, for example, restraining orders. Those sexual harm prevention orders, those restraining orders, and those other ancillary orders of the criminal court will quite often say who a person can't see. They will quite often limit somebody's access to the internet and so on and so forth. So again, they take away that decision-making ability for a person, and they take away effectively the use of the Mental Capacity Act. Finally, I just want to mention prisoners, and in particular prisoners going into hospitals. So I know a lot of you tonight are doctors, and a lot of you work in hospitals as well. One of the things that people get confused about are urgent and standard authorizations for serving prisoners. I'm not going to bore you all with the details of it, but a serving prisoner who is being supervised by a prison officer within your hospital it is deprived of their liberty by another part of the legal framework. And you don't need to worry about the deprivation of liberty that arises from that. You do need to think about any restrictions that arise from their treatment, but that's a separate, distinct issue. And again, that's something which Donna and Ben will expertly cover later. So going back to basics then, as ever, we start with section 3 of the Mental Capacity Act. And we say to ourselves, first off, what is the relevant decision that P can't make for themselves? Is it contact with other people? Is it contact with a particular group of people? Is it a particular care plan, for example, community access or accessing the internet? What is the particular issue that is the core of the case? And then once you've decided your particular issue, you then have to tailor the relevant information to that particular issue. These cases rarely work with those well-trotted out standard lines of relevant information. Because if you go and look at those sort of standard approaches, standard cases, LBX and such like, it doesn't incorporate this stuff. So think about, what does the relevant information include? And remember that it includes the reasonably foreseeable consequences of P deciding to do something or not deciding to do something. And think about if that will include a proven risk of them offending. And I've had a sneak preview of Mike's slides earlier tonight. He's got some great thoughts about that, and I really hope you'll find them interesting too. From a legal perspective, I will fully accept that I spent a jolly long time in the High Court, the Court of Appeal, and indeed the Supreme Court, arguing that in fact, when it came to the relevant information, that the relevant information ought not to be expanded so as to include the protection of anybody other than P. I looked, and other barristers looked, at the principles of the Act, and we said that essentially the principles were about the protection of P and not the wider public. But when you look at the decision of the Supreme Court in JB, and you look at the argument that we put and that John McKendrick, King's Counsel, put on behalf of the official solicitor, you can see that Lord Stevens disagreed. And he said that when it comes to the relevant information, it can include the risks to the wider public as part of the reasonably foreseeable consequences of making a decision or of failing to make a particular decision. So once you've got over the hurdle of establishing somebody's capacity in respect of a particular decision, we then move to best interest. And again, you look at section 4 and you say, well, hang on, Ian, section 4 doesn't mention anything to do with protecting the public. Section 4 doesn't mention anything about keeping P out of the criminal justice system. And you're left again with the delightfully flexible section 4, but also that nagging feeling of, well, how does this all fit into the statutory framework? And again, you're left with the idea that you as a decision maker, or that the court, must consider all of the relevant circumstances as per section 4.2. And then you return to the case law. And the case law starts very early on in respect of the use of the Act. And it starts with the case of ZZ. And in respect of Mr. ZZ, if you don't know the case, Mr. ZZ was a man with a well-established history of offending. Some of it was acquisitive offending. He would engage in various acts of property damage. He himself had been the victim, it was felt, of abuse as an adult within a care setting. But what comes through loud and clear within the text of the judgment is that this man is a man who is at risk of sexual offending. He's at risk of sexual offending, in particular towards children. And the matter went to the Court of Protection. Mr. Justice Moore decided and had to consider whether or not the care plan and the deprivation of liberty that arose from that care plan was lawful and in Mr. ZZ's best interests. Now, the judgment from Mr. Justice Moore reads as if the OS accepted all of this wholesale. And that's not quite right. The OS actually tested the nature of the restrictions. But here, Mr. Justice Moore set out what he felt came in respect to the law when it comes to imposing restrictions where there is that public protection flavour. And he said, I make it clear to Mr. ZZ, I have no doubt that the restrictions upon him are in his best interests, designed to keep him out of mischief, designed to keep him safe and healthy, to keep others safe, to prevent the sort of situation where the relative of the child wants to do him serious harm, and they're designed to prevent him from getting into serious trouble with the police. And you will guess from my colour coding what I'm saying here. So in the bits in green, I have absolutely no problem with keeping P safe and healthy, keeping P from the situation where they're going to be beaten up in the community are clearly core things within the Mental Capacity Act. The bits I put in yellow about keeping others safe and about keeping P away from serious trouble with the police, I've put in that amber alert yellow because there's something you need to pause on and you need to think about very carefully if you're either inviting the court or you're making a decision yourself to impose restrictions to keep others safe or to impose restrictions keeping P out of trouble with the police. And then there is that bit in red. I have no doubt, and I can't speak for him, and I hope he wouldn't mind me saying this in public. I have no doubt that were Mr. Justice Moore to make this decision today, he probably wouldn't have included the line about keeping P out of mischief. We don't impose restrictions to keep P out of mischief. And so again, you have to avoid that sort of general protectionist imperative to keep someone completely wrapped in cotton wool. So how then do you fit in this idea, going right back to basics again? You're there to make a best interest decision for P, which is the least restrictive. You're there to make a decision for P that is in their best interests. But also there's a crossover between potentially keeping P safe from harm and keeping the public safe from harm. And one of the arguments that came up in the DY case was about what was the purpose of the care plan. Now in the DY case, for those of you who've read it, you'll see young man, history of paedophilia or paedophilic interest, subject to a sexual harm prevention order, also was subject to a standard authorization. And Mrs. Justice Judd was clear that overall, a care plan could not have as its primary purpose the wish to protect the public. Rather, going back to those basic principles again, you have to look at P's best interests. And Mrs. Justice Judd said effectively it was a false dichotomy to say that protecting P also couldn't include protecting the public, because she said in this case, and again, I think it's case specifically, you have to be careful, that it was in P's best interests for him not to commit further offences, not to go further and receive further criminal sanctions. And so she felt that this type of imposition of a care plan, so as to allow somebody to be restricted when there is a public protection aspect, was actually for benefit for P and actually fell within the qualifying requirements set out within Schedule A1. So how does the risk of offending get incorporated into a decision? You ask, what is the risk? How do you prove it? What care will ameliorate it? What's the decision? How do you tailor the relevant information? And then you say, what's in P's best interests? Can you justify those restrictions? And all of our speakers tonight will be helping you with those three stages. Thanks very much.
Beautifully done, Ian. Thank you so much, and splendidly on time. I was just unmasking myself No, thank you. That was
Brilliant.
just really excellent to orient us in time and space. So with that kind of broad legal framework, I'm going to hand over to Dr. Mike Layton now, who's going to help us think through how capacity assessments might incorporate a risk or a history of offending. Over to you, Mike. And you win the prize for being on mute.
Apologies for that. Can you see my screen okay?
We can, but you might just want to put it on slideshow. Just, yeah, otherwise we're good. We're in business.
There we go. Thank you for that. Okay, so my name is Mike Layton. I'm a consultant psychiatrist and I'm an expert witness as well. So today I'm going to be presenting on this topic, focusing particularly on incorporating capacity assessments, incorporating risk of offending or history of offending into capacity assessments. So I will move through the slides and apologies for this. So just to start off with, I just need to move my camera over here. And then you can put that under the thing. Okay, thank you. Okay, so just thinking about the ethical context, Ian talked a fair bit about this already, but thinking particularly about the autonomy of P in these decisions, thinking about the protection of P, public protection issues, including hospital and care staff, and people working in this area often encounter this victim versus perpetrator dilemma, which casts a kind of ethical, I don't know if it's a shadow, but it makes it difficult to work in this area for some people because they're dealing with P as a perpetrator, as a potential somebody who may have been a victim of abuse, very commonly a victim of abuse in the past and maybe in the present, and often P has had lifelong social disadvantage. These cases have already been mentioned, so I won't go over them except just to highlight the fluctuating capacity issue and the Wakefield case, which is quite useful in terms of unpicking these very complex cases. So the question really comes following on from what Ian said is how do you build up what's the relevant information? So when I'm doing capacity assessments, I'm trying to sort of build up a picture of what the relevant information is so people are able to sort of answer my questions about it. And I suppose the key thing is that the law is supposed to be quite simple. So it should be, to be a criminal law, you know, to be understandable to the man on the Clapham omnibus needs to be fair and acceptable. It needs to be understandable in order to be fair and acceptable. And so an interesting parallel in terms of one element of the relevant information might be the insanity plea, which might sound like an odd thing for me to say. But I suppose the reason I'm bringing this up is because the insanity plea is for to sort of set a very specific bar for when people actually understand when they're committing a crime or not. So, and there's a little bit of a parallel between that and the Mental Capacity Act. So I'm not saying by any means they're the same things. So in the insanity, if you're putting forward the defence of insanity, then in simple terms, there's a defective reason caused by a disease of the mind that's affected the defendant, and insofar as it made them not know what they were doing, or if they did know what they were doing, they did not know the act was wrong. And this sets a very high bar in terms of being a defence, very hard to reach, or very low bar if you see it as a capacity test. So very few people have such a low level of functioning. Compared to the Mental Capacity Act, the defective reason, the way it's framed is parallel to a causative nexus. The disease of the mind fits in with the impairment of or disturbance in the functioning of the mind or brain. And then the impact on the understanding of the act is very similar to, in some ways, I should say, to being unable to understand, retain, weigh or use. But obviously it's a much simpler area about the act itself. So it's interesting to note that people with insanity can be floridly psychotic, but still not be found insane. And a patient of mine who had Huntington's disease was a good example of this. She set fire to her room in a nursing home, very high risk. There was a floor above her, and very could have led to a homicide. She set fire to her bed. She walked out of the room. She'd stolen a lighter to do this. She went into one of the lounges. She didn't tell anyone. Someone noticed the smell of smoke, raised the alarm, and after the fire brigade had put the fire out, and it was a pretty bad fire. She went up to the police and said that she'd done it because she didn't like the nursing home and wanted to be moved to a specific hospital because she needed breast surgery. I assessed her afterwards. She clearly lacked capacity in relation to residents and care, but she's very clear that she knew what she'd done was wrong, and she just didn't see it as much of an issue. So her judgment was impaired, but she would not have been found insane. So insanity is different in a number of ways. Mental Capacity Act is based in the here and now. It's a decision you're about to make in minutes or seconds, or it's forward-looking future decisions about moving house, about contact, about whether you can conduct proceedings, things like this. So they have a different sort of temporal flow to them, with the exception of criminal prosecutions, which I won't go into, but you can do retrospective capacity assessments if someone is being prosecuted for abusing someone under the Mental Capacity Act. Insanity defence, by contrast, it's always retrospective, and both the evidence is sought, in real time, so it can be presented in court. I'll come on to why all that's relevant, but just to bear in mind, the group of people we're dealing with in these cases where offending is an issue tend to be, the ones that come to court certainly or involve expert evidence, tend to be in the borderline capacity group. So they're people where people aren't sure if they are aware of what they're doing, and they think they may well be. They've got a good understanding of their situation in many ways. So they have relatively fluent communication. They may have mild cognitive impairment. They often have a broadly plausible understanding of many of the issues in their case. Weighing up sometimes is cited as the key problem rather than understanding. And these cases tend to be technically complex in a number of ways. The assessments are complex if you're assessing capacity. Diagnostic issues often complex if you're a psychiatrist or a psychologist, and there's often complex safeguarding issues. And as we can tell from this evening's talk, they're legally complex as well. So obviously the parallel with insanity is only an observation. It doesn't have any legal force. But in the calls of protection, we're kind of encouraged to think about what is the norm, what is inclusive, how do you promote engagement in sort of normal social involvement and activity, including potentially going to court. So seeing what is deemed to be a complete lack of understanding of an offence is maybe a guide to what level of understanding someone needs, though not the only guide. So what are the key issues in these welfare cases? Because that's what they are. They're welfare cases. You're looking at the intersection between offending and wider welfare provision as well. And so obviously there's some degree of ability to understand the law and or of whether it's right or wrong. There is the purported risk of offending that may be relevant. I think you have to be careful not to make that too complex, because that then sets the bar too high, and I think creates a group of people that fall between two stools. They are too well to be kept, under constant supervision, but not well enough to be let out, and it's a difficult balance to strike. And then finally, you've got to think about the welfare provisions that might mitigate the offending. Okay, so these are the kind of offences we're talking about. Sexual offences, very commonly on and offline, harassment and stalking, non-sexual violence offences, other online crimes, and occasionally arson. Important question for people to ask themselves at the beginning when they're looking at one of these cases is to step back from everything that's said about P and just ask yourself the question, especially if you've met P or read a transcript of P talking about something other than his offending or her offending. So is it plausible that they don't realise the act is wrong? Because this is often where things seem to fall down in the cases I've seen. It's not asked enough, this question, and it tends to get to quite a late stage before all parties really engage with this idea. Now, I'm not going to go into the DY case because we don't have enough time, but if you get a chance to read it, Dr. Ince's summary of the conversations he had with DY is very telling. And when you read them, you really get a sense of how capable DY was. And when you do these cases, which I've done quite a few of now, I can see Dr. Ince has encountered very similar scenarios to myself here, in terms of someone who really is very fluent and really nicely able to give an account of themselves and their situation. So in terms of in a sense, you're trying to construct a matrix of relevant information for P's particular case. There'll be the different elements, like you mentioned, like residence care, online contact, and this rule, if you like, that they're said to be at risk of breaking, the criminal element. So you need to ask yourself, do they understand this in basic terms? And I've done a Venn diagram, which is one of my little habits in these talks. So that's a very small piece of information. So it's represented by this little square in the middle. That's your offence rule. So that's the first bit of relevant information. Then you want to build this up because there's other issues. So in these cases, there's often a residence factor to consider. I'll come into the details of that later on. Residents have got a lot more content to it. It's a bigger circle. But it is very rarely just about residents. And so we find care being added in as well. And now we're starting to see how much more messy this all can get about where you categorize your relevant information. And then, of course, our good friend online and social media, which you see doesn't go into residence, but does go into care and the offence rule. So we're very quickly into a complicated situation. I didn't put contact in here, or alcohol or drugs or gambling, simply because you can imagine the mess we'd be looking at. But no wonder when you see this kind of diagram, that it's an area which people struggle with in terms of how to formulate what's the relevant information and how to assess individuals in these situations. You can imagine we could have 5 circles there quite easily, and if finances affected offending, we could have 6. So just some examples really of some of the factors to consider. So when we're looking at residents, we know there are these sort of standard criteria we're given to look at when we're trying to work out if someone has capacity around residents. And but there are some things which are very much more specific to these kinds of cases where there's an offending risk. So often there'll be a requirement to live in, or an expectation a person will live in a single gender placement because of risk to a particular gender. They may be particularly high risk and have to live in a single occupancy setting, and very commonly has to be 24 hours staffed. So that would be part of the relevant information. The area may be important. Proximity to a school may be relevant in terms of someone who's considered to be a risk to children. There may be ready access to drugs or alcohol, and that may be something that affects offending. And then there are people around in the area who may affect risk. So this may also jump into contact, but just the proximity of certain people in certain areas. So being close to abusive family or an unscrupulous or deviant peer group. All of those things may have an effect. You then look at, as Ian mentioned, some of the legal restrictions that could be placed on P. Now, they wouldn't have capacity, they wouldn't have any legal right to change them, but under some of these orders, people may move residence, and they may, under some of these orders, be able to contribute to the choice of a new placement. So, as part of that process, they might then be assessed as to whether they have capacity or not. For example, someone being discharged from CTO, someone being discharged on long-term Section 17 leave, someone being discharged from hospital on Section 41, and someone subject to a sexual harm prevention order who maybe has a choice of a couple of placements in similar locality. So there are possible options where residents there may be some flexibility where P is able to contribute to that process. Some services have special rules about alcohol use, drug use, and of course visitors in bedrooms. So all of those are relevant. If you're talking about care, the standard ones that you mentioned is about having one-to-one in the community. And you might introduce here in risks from alcohol or drugs. I think the most important one is the idea that the care provision in the overall picture, the big picture thinking about care provision, because often in these cases, having that prevents offending or reoffending. So, and that's often where people will fall down. They'll understand the different elements of their care, but they won't see how when it's brought all together, that actually really does help them in some way. So that's a crucial thing to understand and use. And then there can be some overlaps with other areas like internet use, and when that falls into care, when that falls into the standard criteria, how visits and contact arrangements might be managed by staff, and certain activities like gambling. So some of these things don't fit neatly into care, may have other areas of law, may need a specific creation of relevant information as the case goes along. So when people are found to lack capacity, often it's related to care, and often people have a bit of a fudge where they've said, yes, they don't have insight, and there are different fudges. Insight is one of them, and this is where people are making unwise decisions and found to lack capacity. Important to bear in mind that you can't use insight as a simple catch-all term for why people lack capacity. If you look at the Venn diagram, the blue area is people who lack capacity, the pink area is people who are making unwise decisions. So you can see it's a small subset. And if you're not in the blue area and you're getting in trouble with the law, then it pushes you very much into the Mental Health Act or criminal justice system territory. And there's a good paper on this by Neil Allen, which goes into it in much more detail. So another thing not to assess as incapacity is cognitive distortions. A lot of offenders deny, minimise, rationalise, blame the victim, or outright dishonesty about the offence. In themselves, they're not part of the mental disorder. You might argue they're part of personality disorder. I really don't think you can use that to say someone lacks capacity in itself. In autism cases, people may talk about not having theory of mind. It's important to bear in mind there's a distinction between not having theory of mind and not knowing what the rule is. So someone can have problems recognising when someone is consenting to sex, but it doesn't mean they don't know they have to establish that. And what I'm getting at here is the idea that people with lacking the problems of theory of mind, it's a spectrum of ability or disability. So people can know that there are social rules, they're just not very good at doing them. And those people can't say, well, I'm not very good at doing that, so I lack capacity. It's not a defence, I don't think. And it's not a reason to think someone lacks capacity either, to say, oh, well, I knew you should get consent, but I'm just not good at getting it, so I just made a mistake. I think it's a bit like saying, if I drove a car after I lost my sight, I didn't have capacity to make that decision. Of course, I had capacity. I just shouldn't have done it. So you have to unpick theory of mind really carefully to make sure the person really doesn't understand the risk they're getting themselves into. And similarly with empathy, you can't use empathy to say someone lacks capacity. And then things like in the moment changes of behaviour. I think on their own, recklessness, red mist, impulsivity, these are not mental disorders. But you do consider fluctuating capacity and things like crises and meltdowns, like the Wakefield case, which is really helpful framework for that focuses on P's autonomy rather than the protection imperative. So when you're talking about risk of offending, this is quite a grey area about whether you're in or out of the kind of capacity group. And often people will have said when they're being interviewed in preparation, being interviewed as part of their capacity assessments, they may have said there's just no risk. And this is often in the context of years and years of arguing with people that supervise them. And you can't really just take that as right, oh, well, they said there's no risk, they don't understand the risk, they lack capacity. And so this is very much when you're doing your assessment, you're thinking about how do you build a good rapport, a non-confrontational approach. So you can really have a discussion about what other people may say to P about their risks. And often P can say, oh, my social worker says I'm going to do this. They can open up and tell you about it. And then you can see why P disagrees about their risk, which is quite different from not understanding their risk. And the disagreement doesn't have to be incredibly sophisticated. It's just important they can recognise they're wrong. I think that's the most important thing. They can understand that they may not be right in their appraisal of their own risk. So they don't have to agree with the risk assessments. Right? Now, in terms of contact, this is a very complex area, and this is much more abstract than care and residence. It brings in the third-party dependent factors, and so you need to have a lot of information about the third party, a lot of abstract stuff about interpersonal functioning, and issues about exploitation into offending, the impact of conflictual or abusive relationships that could trigger offending, and this often, because it's so nuanced and subtle, is just too complex to make it part of a capacity test, and so it's unfair. And often then leads you in the direction of the inherent jurisdiction of the High Court. But a lot of people will still struggle with the contact test, much more than they will with residence or care, because of the abstract nature of contact. But as I say, within the borderline group, there are a lot of people that can do quite well on contact assessment, on the assessment of contact for capacity for contact, and you then start to look at the inherent jurisdiction. I think the online and social media is an interesting one, because obviously in the case, the sort of leading case on this, There's this phrase about the risky territory, about looking at extremely rude or offensive images or messages online. And this, makes you think very clearly that a lot of people who may not have capacity in some areas often are found to have capacity for online and social media. And for people that don't cooperate too much, it can be useful to look for evidence of secretive behaviour and unguarded comments about their online activities, because some people may be lying about their behaviour. But in the offender cases, I will adapt them to look at things like harassment, the risk from paedophile hunters to them, and hacking is one I've been asked recently. The other one, which I don't know the answer to, is whether you can talk about the impact of internet overuse on behaviour, because in the leading case, Justice Cobb explicitly excludes addiction, which is remarkably similar to getting angry if someone stops you using the internet. So it's an interesting one, and I don't know the answer to that one yet. So when you're approaching these assessments, allow yourself plenty of time. You need to do several assessments. You need to look at P's background. They're much more likely to be alienated from professionals. Clarify that matrix of information in advance and work through the easy, non-contentious stuff first with P to build that rapport, to get to know them well. Keep the approach nice and conversational, just like Dr. Ince's report. Just having that conversation approach gives you so much more useful information, so much more of a plausible understanding if P really does understand and use the information well. So when you build your rapport, think carefully about when you're going to have to challenge P, and if you need to challenge them at all. You may need to challenge them, but be very careful and minimise the need to disagree with them. Use depersonalised examples about the behaviour. So some of you may have read reports of mine where I've talked about all kinds of nefarious things I've been up to online, and the person you're interviewing tends to find that quite amusing, and that breaks the ice and makes it a lot easier to explore these issues. And then you can revisit the issues using practical examples, so you're coming from different angles to see that P really understands the underpinning logic and isn't just giving you a rote-learned answer about risk. Sometimes the patient will be, or the P will be, unhappy with the process and the system, and as a result, it can be hard to have a meaningful discussion about this, and they won't cooperate with your assessment. You may need to narrow things down, focus very clearly on what their understanding of right and wrong is, give them examples, ask them why they think something is illegal, and then check for third-party accounts. One person I saw for a case who had been involved in child offences prior to and during my series of assessments had told his care staff that the police won't do anything because he's got a disability, which chimed very much with my interpretation of his understanding. So some people are completely uncooperative or near completely uncooperative, and normally you would not submit that assessment because it is so sketchy. You have to persevere, try several times. If that fails, I have a careful discussion with the parties about how to proceed. I tried to use a process of triangulation of evidence to see what we can find out from third-party reports and historical information. There's a case I did with Ian called EOA. There's two cases. The second one of those I did with Ian where we had to take that approach. And I've used this in several other unreported cases as well. So summarising really, when you're formulating an opinion or an analysis, you're trying to have the relevant information containing the offence itself or the risk behaviour, and then the associated care needs that are put around that to minimise that happening. The weighing up focuses on risk to an extent, but that needs to be the basic level, and it's got to take account of the potential for a capacitors peak and testing and denying their risk. So essentially, can they understand why people are saying they're a risk rather than agree with it? And when you're trying to summarise things and give an opinion, be clear about the overlap areas where the case law isn't sufficiently developed. So hacking, online stalking, and you may need to give a range of opinions depending on how the law is interpreted. So I will finish up there. Just to bear in mind, quick comment about the practical and ethical issues, that there are complex issues around what to do if someone's found to have capacity, and something which your report, if you're an expert like me, can't be disclosed as part of criminal proceedings in an easy fashion. And it's important to think about what do you do if you're leading up to a scenario where P may be found to have capacity, people weren't expecting that. What's going to happen to them? Are you going to put them at risk if you suddenly pull away their supervision? How do you balance that finding against public interest and against the impact on P. And so sometimes people in these scenarios are looking at things and trying to work out before the final ruling or final decision about capacity is made about what they can put in place to prevent things. So there's an interesting debate, I think, to be had about that and what kind of things you can do to limit, their risky behaviours in areas where they lack capacity as well, like limit their money. So there are things that people do which may warrant some ethical consideration. So thank you all very much for listening, and I'll finish there.
Thank you so much, Mike. That was just fantastically rich in so many different ways. And to answer what a question that many people have, yes, the recording will be available, and the slides are going to be available afterwards as well, because I know many people, myself included, would really like the chance to kind of go back over some of what you've said, just because it's so, it's just covering so many different areas. So Mike, can I just invite you to stop sharing so that I can then hand over in 1 second to Caroline? And also thank you again, Mike, for sticking so brilliantly to time. One thing just to add also is just to read, I didn't actually say at the beginning, if you've got questions, we are going to have a dedicated Q&A session at the end, but do feel very free to put questions in the chat, in the Q&A box as we go along, if there are things to, as well, make sure you don't forget. But now I want to hand over, it's not something completely different at all, but it's a completely different zone to be thinking about. And I want to hand over to Caroline Liggins to be thinking about protections for people with mental health / capacity issues in the police station. Over to you, Caroline.
Thank you, Alex. I appreciate that. Hopefully everybody can see my screen now. I'm going to be talking about the police station and what that entails. So I'm just going to put it basically to you.
Caroline, we can't yet see your slides. Sorry, we can see you, but not yet your slides.
Oh, apologies. Hang on.
That's all right.
Let's try that again.
We're 1 minute ahead of time, so you have a minute in which
There's always one, isn't there? There's always one, and it worked so smoothly earlier. Bear with me 2 seconds. Hopefully, are we good?
We are good now. Yeah.
Fantastic. So basically, I'm going to be talking about police stations and how we deal with vulnerable and young people at the police station. Just to put it into perspective, what we are looking at this evening, there are 2 types of police station interviews. The one in which the person is taken to a police station after they are arrested. Obviously, if you've been arrested for an offence, the police officers at the police station will usually interview you in order to gather information about your involvement in the alleged offence. You do not have a choice as to whether you participate in the interview, but you can choose not to answer questions and exercise your right to remain silent. Now, that's very important, and I'll explain why later. A voluntary police interview is where a voluntary interview usually takes place at a police station. However, I've had it in different places, from care homes to actually attending someone's own home to have when they've been so vulnerable. I've made representations about it, but it has happened. You will be given advance notice and asked to attend the police station at a certain date and time. Unlike an interview under arrest, you are free to stop participating in a voluntary police station interview at any time. You can also choose to leave the police station interview. If you do not want to complete the interview, you have exactly the same rights. If you are vulnerable in these cases, you have the right to an appropriate adult with you. There is potentially the ability to discuss with an officer whether it really is needed, especially given if we're talking about someone's capacity. Now, the fact of it is, and many of my colleagues always laugh at this, my theory is always you don't ask, you don't get. And I always make those representations to make sure that if there is any relevance to actually attending the police station interview, because a lot of the time with these voluntary interviews, a lot of this can be dealt with prior to the interview taking place. Usually a voluntary police interview takes place where the police do not yet have any legal grounds to make a lawful arrest. In order to arrest a person, a police officer must satisfy the test is set out in section 24 of the Police and Criminal Evidence Act, also known as PACE. That states that in order to make an arrest, a police officer must have the knowledge or reasonable suspicion that an offence has taken place, is taking place, or is about to take place. So the issue we have with capacity is it can be very difficult at the police station stage, as you don't have the reports and resources. It's normally either your gut feeling as a solicitor who has seen many cases come before through the police stations, and an appropriate adult who knows P very well, or an FME at the police station that's able to guide you through this. Now, vulnerable P. So as I said, today I'm going to give you a whistle-stop tour of how the police should be dealing with vulnerable people at the police station. You must always be aware that the vulnerability of P may not always be obvious. We've had this numerous times where we have gone into the police station and explained the position to the police officers, and they just have not listened to us at all. As lawyers, we are trained to probe for instance, for evidence of autism or special needs supports as a child. No interview may take place if the suspect is unfit. This requires an assessment of the risk to the detainee's physical and mental state and determine what safeguards are needed. We will also need to make representations of this. Again, it's a very difficult position to find yourself in, trying to make those arguments against the police, because it's not always very easy to do so. As a lawyer, our role is to advance and protect the rights of the vulnerable P in accordance with their instructions. There's also, and I'm sure that you've all heard of them, appropriate adults. Their role is to safeguard the right, entitlements and welfare of a person of 18 or younger and the vulnerable person. There also have been discussions about intermediaries should also be in the police stations as well, as they bring a very different role to the position. I've been in cases where both myself and the appropriate adult have said our client was clearly not fit for interview. I appreciate we are not medical experts, but we see enough. The police still continue with the interview. I made a statement at the beginning of the interview stating the position with regards to what my client was stipulating. And at that point, he did not answer any questions to the questions put by the police. The appropriate adults, as I said from the outset, are pinnacle. They are the ones that are setting the scene with regards to the person that you are meeting for the first time, in particular those ones that are family members. You also need to be very cautious as a lawyer that you are setting the scene for the progression of the case within criminal proceedings. And it's very important that you get it right first time and are diligent to what you are doing. The rights of a mentally vulnerable P are summarised in Code C Annex E of PACE. If an officer has any reason to suspect that a person of any age may be vulnerable, in the absence of clear evidence to dispel the suspicion, the person shall be treated as such. To establish whether those may be the position, the relevant officer should make reasonable inquiries to ascertain what information available that is relevant to the factors indicating that a person may be vulnerable. Again, this is something that should be happening more and more, but unfortunately, as lawyers, we are the ones that are fighting this and always putting out that our clients are vulnerable. The amount of times that I go into interviews wanting to stamp my feet, but obviously not, suggesting that there is a position that my client is vulnerable, and then still continuing with the interview is absolutely appalling and concerns me greatly. The term vulnerable applies to anyone who, because of a mental condition or mental disorder, many may have difficulties understanding or communicating effectively about the full implications for them to investigate procedures, does not appear to understand the significance of what they are told or questions they are asked, or of their replies, appears to be particularly prone to becoming confused and unclear about their position, providing unreliable, misleading or incriminating evidence without knowing or wishing to do so. accepting or acting or suggesting from others without conscientiously knowing or wishing to do so, or readily agreeing to suggestions or proposals without any protest or question. And this is the difficulties that we have often with these cases. And the fact of it is that we as lawyers have to be constantly pushing for the position. What we have to remember is that although people who are mentally disordered or otherwise mentally vulnerable are often capable of providing reliable evidence, they may, without knowing or wanting to do so, be particularly prone to, in a certain circumstances, to provide information that they may be unreliable, misleading, or self-incriminating. Special care should always be taken when questioning such a person. At the appropriate adult should be involved if there is any doubt about a person's mental state or capacity. Again, the amount of times we as lawyers have arguments with the police about having such as having appropriate adults in the position, and us actually going into interviews without appropriate adults and having to make statements is again scary. Because of the risk of unreliable evidence, it's important to obtain a corroboration of any facts admitted of the risk of unreliable evidence. It is important to obtain corroboration of any facts admitted whenever possible. As we know, mental disorders are defined by the Mental Health Act 2007 and as a disorder or disability of the mind. This is very wide and can include clinical depression. A person with learning disabilities should not be considered by reasons of that disability to mental disorder unless the disability is associated with abnormally aggressive or serially irresponsible conduct on their part. Dependence on alcohol or drugs is not itself considered to be a disorder or disability of the mind, but it may become a disorder, as for instance, with alcohol dependency syndrome. Again, I've dealt with a lot of clients that have had this and who are sitting whilst we were trying to interview one of them and actually withdrawing, and it was absolutely awful to see. And this is a battle we often have, may still be vulnerable even if they do not have a mental health condition or disorder. You will need to give careful consideration to whether the suspect is fit to be detained. You have to make sure you are always really pushy with this point. You will always have a unique confidential knowledge of the young person or the vulnerable person. Again, representations will need to be made, whatever the view may have been expressed by a healthcare professional. Also, the police should be making sure if the vulnerable person has committed an offence, this information should be passed on to CPS to see whether formal action is necessary. I have in the past put forward representations at this point. If the person is able to meet the requirements of a caution, this might be an option. If cautions is not an option, the police should consider whether action really is needed. Mental health defences and issues. If issues may arise of insanity, lack of mens rea, or unfitness to plead, consider appropriate ways to deal with the matter on record. For instance, be by a carefully worded prepared statement that identifies the potential defences. I have on occasions actually not even put forward a prepared statement. I've actually said something on behalf of the client in the interview due to my concerns of them actually being interviewed. Where defences depend on the mental state at the time of the alleged offence, consider the need urgently to seek expert medical advice. A lot of my young clients who I've represented before have such medical reports. I always make sure I have a copy when I'm attending the police station, and I also make sure others do as well. You must always be mindful, though, as an account given by P may later feature an assessment of P's ability to participate in the trial process. There was one case in particular that I want to share with you this evening. It's a case, and actually my young client is back in the police station again. And unfortunately, I won't be able to go out and deal with him. But he's a young lad who, after many reports we gained for him, he had the mental age of a 7-year-old, so that underneath the age of criminal responsibility. We sent numerous letters to the CPS. He was charged with the offence. We had this report for his police station. He was then charged for the offence, and it was after several letters of representations, considerations of whether a caution would be acceptable. Obviously, due to his mental age, it wasn't. that we decided that we were going to JR the decision for them to prosecute my young client. It was only on the day that we were issuing the JR did we receive the letter that our client's case would be discontinued. However, I know that we will be using the same report today at the police station, and my young client, I know, will still be interviewed because the police will not accept the position, even though a medical expert has given that he has all aspects of a spectrum disorder, but also that he has a learning disability and should not be interviewed due to his age. Thank you for listening to me this evening. Obviously, there'll be questions afterwards, and I will hand back over to the next speaker.
Brilliant. Thank you very much, Caroline. The one thing you failed to do in an otherwise absolutely brilliant talk, and this is my fault, is to introduce yourself. So people have been able to guess possibly, but I just think it's important. Just tell us who you were.
I'm so sorry. Apologies. It was just because apologies. I am looking at my phone as well because my client is imminently at the police station, so I must apologise. But I'm as you can see, I'm Caroline Liggins. I'm head of the youth team at Hodge Jones and Allen Solicitors. I'm a partner there. My main area is young clients, but I deal with a lot of vulnerable clients as well, and that is my bread and butter, if I can put it like that.
Brilliant. Thank you so much, Caroline. Really, really important stuff. We're now going to move to, as it were, the next stage in a sequence. So beyond the police station, thinking about prisons. And so I'm now going to hand over to, this is going to be a double act between Gavin Dingwall and Jessica Gallagher to be thinking about, well, the statistics around mental health capacity and brain injury in prison and approaches to sentencing. So over to you, Gavin and Jess.
Okay, hopefully I've unmuted. I don't quite know what you're going to see of me here. We don't have slides. Let me introduce myself first. I'm Gavin Dingwall. I'm Senior Research Fellow at the Sentencing Academy and a visiting researcher at King's College London. And the way we're going to divide this today, I'm going to start by talking about some of the sentencing issues. And then Jessica's going to take over and she's going to pick up on mental health issues in prison. And what I'm going to do is I'm going to focus just on 5 issues which appear to me as a sentencing scholar to be really interesting points raised in the relevant sentencing guideline on sentencing offenders with mental disorders, developmental disorders, and neurological impairments. Obviously, I'm going to have to skip through this pretty quickly because Jessica's actually quite frightening. And I'm not going to go through, for example, options available to sentencers. There's a lot of them. If you are interested in that, they can be found listed in Annex C of the guideline. So I'm going to pick up on 5 things. The first thing I want to talk about, I've actually called the irrelevance of mental disorders, developmental disorders, and neurological impairments. After that, I'm going to talk about culpability. That's something that sentencing scholars like to talk about. The third one I'm going to talk about is one which, the more I've thought about it, the more it actually strikes me as one of the key things to remember with regards to these categories of offender. So I'm going to talk about minor offending. I'm then going to say something very briefly about community sentencing and the need for punishment before finishing with the custody threshold, which hopefully will sort of link quite nicely to the material that Jessica's going to talk about. So let me explain what I mean by the irrelevance of mental disorders, developmental disorders, or neurological impairments. I don't want to sort of completely ruin the purpose of tonight's presentations. I want to pick up on paragraph 2 of the sentencing guideline. And it basically just states that the fact that an offender has an impairment or a disorder should always be considered by the court, but will not necessarily have an impact on sentencing. So the key point here is that the sentencing guideline, first of all, won't always apply, in that quite a lot of people with mental health disorders, for example, will be treated in exactly the same way as people who don't have them. And that's quite important when Jessica talks about mental health in prisons. But it also links to my next point, specifically about culpability. But it is important to remember that the law is quite clear in this. In many cases, mental disorder should just not impact on sentencing. So my second point, culpability. Culpability is vital in the sentencing exercise. Section 63 of the Sentencing Act 2020 says it's central to any assessment of the seriousness of the offence. The seriousness of the offence is basically what determines the appropriate disposition. The guideline again stipulates that just because somebody has an impairment or disorder, it doesn't automatically mean that their culpability is reduced. It follows on from my last point. The guideline actually then lists 3 questions which the court might find useful in determining whether or not culpability is reduced. I won't go through them, we are very strapped for time here, but it's unusual. A sentencing guideline saying that the court might find something useful as opposed to the court, must go through these stages is fairly unusual. I then want to just say 3 things about particular dispositions. Now, the first relates to minor offences. And this, as I say, strikes me as really important. Most offending is minor. And academics forget this all the time. We're fixated by the worst offences and the most dangerous offenders. But in fact, over 78% of those sentenced in the year to September 2022 received a fine. And I really welcome the fact that this sentencing guideline stresses that in minor cases, the appropriate disposal may be a fine or maybe a discharge. I think there's a real danger sometimes that somebody who has a disorder or an impairment actually can receive a disproportionate sentence. Maybe the sentencer is acting from the very best of motives, but I think proportionality is really important if we're talking about culpability. And also, we just have to recognise the reality of most offending. Community sentences, the second disposition I want to make just a small point about. This can seem to be a particularly appropriate, possibly a particularly effective disposal, especially when you've got orders such as mental health treatment orders. The thing I'll say as a sentencing scholar is that, save in exceptional circumstances, at least one requirement has to have a punitive purpose and or a fine. Now, in cases involving someone with mental disorders or developmental disorders or neurological impairments, the court might find exceptional circumstances. But again, I think it's really important to bear in mind the presumption. And of course, to also bear in mind, as I said earlier, that the court might conclude that the person's culpability in committing the offence is not in any way affected. Now, finally, custody. In particular, the custody threshold. And here I'm talking about cases which are on the cusp. Now, the guideline states that an offender with a mental health disorder, developmental disorder, or neurological impairment may avoid custody at this level on 2 distinct grounds. The first, that it would be disproportionate. And presumably what we're talking about here is disproportionate based on the offender's culpability. And this accords with the usual threshold for imposing custody, which concerns the seriousness of the offence. But again, point I made earlier, culpability is not always going to be reduced in cases where somebody falls into this category of offender. Second sort of ground for avoiding custody is one of public protection. The argument is public protection is better served in some situations by a rehabilitative approach. As a SAVO, the courts may still conclude that the custody threshold is reached, prison is appropriate, and then I'll let Jessica take over and talk about issues when offenders you're going to take over from when offenders reach prison. Thank you.
Amazing. Yeah, thank you. Hi, I'm Jessica Gallagher. I'm a lecturer in law at Birmingham City University, and I'm also a PhD researcher, and I research self-harm and suicide and the impact of the prison environment on both of those things, and I'm effectively trying to make the link between whether those exist independently or whether they're as a result of the prison environment. So mental health, the prison estate, all of these things are areas that sit where I do. So yeah, I'm finishing off, I guess, kind of everyone's moved quite nicely on to where I sit, which is custody and prisons. I'm going to focus on just a single element, and that is custody and the effect of the deteriorating effects of prison for those who are already mentally disordered or suffering from some sort of impairment or developmental disorder, and looking at the true impact of prison on that. I'm going to focus on some of the concerns we have around imprisoning someone with a mental disorder, focusing on the known effects specifically regarding overcrowding as both an individual and an environmental factor, a little bit touching on some of the theory around this, the pains of imprisonment, deprivation and prisonization, and then some thoughts on the specific sentencing ideas, just to kind of vaguely bring it back to what Gavin does. But when we were talking about this, a specific area that came up for me as a prison researcher was this area of the sentencing guidelines that stated where custody is unavoidable, consideration of the impact of the offender may be relevant to the length of the sentence. This is because an offender's impairment or disorder may mean that a custodial sentence weighs more heavily, or because custody can exacerbate the effect of these conditions. And this was kind of a red flag to me, this idea that in writing that custody might exacerbate the effects of these conditions. And this is something that is not a radical idea, I think, either in penology or in criminal justice or in law more generally. The idea that prison is a harmful tool, sometimes necessary, but often harmful, with an impact on those who are incarcerated, doesn't feel radical at all. That's not the conclusion of this. But the understanding of that is the chicken or egg of this research. Is the person entering prison, is the person entering prison vulnerable because of their mental health, or does the prison itself and their environment make them vulnerable? And what we know is that there is an impact of prison. We know that you don't leave prison having not taken any of that on or experienced that in any negative form, but we aren't exactly sure which factors are so impactful. And I was looking at this and aware of the time limit and aware of how much we needed to talk about. And I wanted to talk on kind of one specific issue. And I thought, in considering where we are in English and Welsh sentencing in prison, that overcrowding made the most sense to talk about, because this is in effect a factor that has two elements, and that is that it is an individual and an environmental factor, and has huge impact on both the inside world of that individual as well as the wider experience of them as they go through the prison estate. It's been theorized in some research, predominantly in the US, but starting to be seen over here, that overcrowding is a stronger predictor of prison suicide than any other prison-specific variables, which of course is interesting to me. Curie and McNulty in 2005 seemed to think that overcrowding is one of the more detrimental prison-specific variables that we see. And we consider this to be something like warehousing, which according to Tock in 1985, is down to the fact that it has such a reduction and denial of access to substance and rehabilitation services. And that's something we'll come back to, this idea of reduced rehabilitation services. And the overcrowding only exacerbates cognitive strain. I think that use of cognitive strain is interesting because it doesn't necessarily refer to a specific mental disorder or concern. It's a strain on whatever is going on in someone's brain or mind at the time. And we know that overcrowding affects all areas of life. It impedes the adjustment to the prison estate, likely has implications to the prisonization process, which then has implications to rehabilitation. It creates struggles for autonomy, it increases the likelihood of suicide, and it negatively impacts on both space and wider environment. But to bring it back to England and Wales, this is something that we're pretty aware of here, is that the standard of overcrowding is only getting higher. We currently sit at around 80,000 prisoners, a little bit less, where we've sat kind of gradually growing to, especially over the last half a decade, and predicted rise of 20,000 prisoners within the next 5 years in a prison state that doesn't really have the space for that, which has implications for the basics, for prisoners being able to have showers and food and jobs and ability to exercise and to be educated, but also for mental health support. Mental health support is something that we know to be an issue in prisons. The current standards aren't fantastic. The prisons follow the stepped care model, which is that at the very bottom you have what we refer to as self-care, effectively people looking after themselves, taking ownership of their mental health. And then right at the top, we have the most specific, nuanced and kind of, I guess, kind of medicalized psychological support. So that's where we have the psychiatrists being involved. And for us, all of our individuals we've spoken to today will be somewhere on that model, more likely to be at the top. The prison system is really good at supporting the bottom of the stepped care model, mainly because it involves individuals, being on their own, looking after themselves. The prison state doesn't have to have much involvement in that. But the ability to support and offer variety that isn't just the kind of same treatments replicated for all individuals at the top of the stepped care model is significantly more reduced. These are individuals who receive significantly less support. And for those who require the most support, that require mental health support in prisons, that is something that is really lacking. And while there are specialist mental health units, these exist in 2 prisons, in HMP Durham and HMP Swaleside, and these are integrated support units where individuals can go. There's 15 cells in each of these wings, and they allow them to have that kind of very specific, intensive mental health care support, but with around 30 beds in the whole country. It's something that we're not seeing people being able to access in any kind of strong capacity. We're seeing more individuals being sent to secure hospitals than ever, over 1,000 for the first time in 2021. I imagine probably similar in 2022. So people in prisons are, by objective standards, suffering more. And from anecdotal and empirical research, we're seeing that this seems to be an issue in it's growing. But the issue is, and the issue regarding that sentencing is that sentencing guidance didn't say that custody shouldn't be used. It stated that custody is unavoidable. There should be a consideration of the impact of the offender, regardless of the fact that custody may exacerbate the offence. So where we sit at the moment is, I guess, balancing those 5 aims of sentencing. We know there isn't a question of not being in prison, but we also don't really have another option for those who are involved in that scenario. We've got these 5 aims: punishment, reduction of crime, reparation, rehabilitation, and public protection. And as Gavin touched on, there will always need to be an element of public protection. And with custodial sentences, we're always trying to aim clearly for that kind of aim of punishment. If there's one thing we do well as a prison system, it is punishing. Whether we offer any formal rehabilitation or deterrence after that is a bigger question, but one I don't have time for. But balancing this sentencing guideline, especially as Gavin said, where mental disorders aren't necessarily considered as specifically, as well as considering that what we know that putting someone into this environment is only going to have a detrimental effect, is something that is a really difficult one to balance, especially when we talk about questions of capacity, or when people, as other people have mentioned this evening, are mentally unwell but have capacity. Again, not all individuals in prison, as Ian said at the beginning, lack capacity. They're all capable, all kind of, some have capacity, some don't, and there are a lot of decisions to be made in prison on a daily basis. But these specifics in the sentencing guidelines doesn't offer us much. It doesn't offer us specific support that can be useful in when we're dealing with these offenders. And as someone that really only focuses on this element of the criminal justice system, it's concerning to see some of these cases come through and see people kind of stay in prison for a while, get significantly more unwell, and go to a secure hospital when it feels like there is the potential that secure hospitals may be a better option if better funded and better governed. So a little bit of an insight into where we are with prisons. It's not great fundamentally, but I guess I'm kind of filling the gap in the other end compared to some of the people dealing with police stations.
Brilliant. Thank you so much, Gavin. Thank you so much, Jessica. Again, both of you covering just such fascinating things. I have to say that your presentation, Jessica, was reminding me of very vigorous debates taking place during the independent review of the Mental Health Act about what on earth do you do, and do we just say, actually, this is all so awful, we should make the Mental Health Act apply in prison, which, you know, where do we go? But, well, where do we go? Except where we go is to Donna, Donna Phillips, who's going to be helping us actually think through some of the dilemmas in relation to prisoners where we've got issues about capacity, consent and healthcare. So I'm going to be Donna's tech support here. So bear with me just 1 second while Donna introduces herself. I'm going to get your slides up.
Fabulous, thank you. Hi everyone, so I'm Donna Phillips and I'm the head of safeguarding at Spectrum Community Health. So Spectrum is a not-for-profit community interest company. The largest part of our portfolio is providing NHS commissioned enhanced primary care services into secure estates across the north of England. Jessica's session leads on really well to what I'm going to be talking about. So prison healthcare is one of the most interesting and challenging fields of health provision. And there's no doubt that our staff work with some of the most vulnerable and marginalised groups of people in our society. What I'm going to talk to you about this evening is some of the issues and challenges working with patients in custody who might present with extremely complex and multifaceted issues, and the interface between healthcare in prisons and the law, such as issues around mental capacity and consent. And hopefully I'll add some interesting context around issues that have already been discussed today from a prison healthcare perspective. Can you move on to the next slide, please, Alex? Thank you. So, although research in this area is really limited, the Centre for Mental Health in 2021 estimated that 70% of people in prison met the criteria for 2 or more mental health diagnoses. So, with the possible exception of autism, all vulnerabilities have a prevalence rate far in excess of that within the general population. So, the experience of trauma and adverse childhood experiences is very common amongst people in prison, so it should therefore come as no surprise that patients in prison may present with a wide variety of high risk and complex health and psychosocial needs. Adding further complexity, the prison population is ageing, so therefore the instances of patients with dementia and other age-related conditions is on the increase. Patients within prison settings are a particularly vulnerable group of people with complex needs and potential high levels of risk to themselves or others. The Care Act specifies that the local authority where a prison is located is responsible for providing assessments and meeting the care and support needs for residents within it. Care must meet the same standards and be equivalent to that which would be expected within the community. Section 42 of the Care Act, which relates to safeguarding inquiries by local authorities, doesn't apply in prisons, and the overarching accountability for safeguarding lies with the prison governor. However, safeguarding adults boards can provide advice or assistance to any person for the purpose of helping and protecting adults with needs for care and support who are at risk of abuse or neglect, and that includes people in prison. But in my experience, this is a rarely utilised resource. So prison governors may be invited to sit on safeguarding adults boards within the local authority areas, but the Act does not require them to do so. Our organisational ethos regarding what constitutes a safeguarding concern within our prison settings exceeds that which would be generally recognised within a community setting. So as per the Care Act, a statutory safeguarding response is triggered for an adult with care and support needs who's at risk of abuse or neglect, and due to these care and support needs is unable to protect themselves from that risk. So when we train our staff, we refer to these statutory safeguarding duties as safeguarding with a capital S. Adults who don't have care and support needs wouldn't always meet the criteria for a safeguarding response in the community. Prisons are highly complex settings, and individuals who may not have been at risk when in the community may find themselves in an environment which means that they require safeguarding. So, for example, a person with a neurodiversity such as autism, Asperger's or a learning disability who wouldn't necessarily meet the criteria in a community setting as defined by the Care Act may be vulnerable within a prison environment. So within a prison, all patients may need safeguarding with a small s. Primary care services in prison work with a concentrated population of people with complex issues which are out of proportion with community primary care services. The enclosed prison environment means that healthcare staff have a heightened awareness of individuals' day-to-day lives, their poor health choices and risk-taking behaviours which community primary care services may not have. Healthcare in prisons may provide opportunities to intervene earlier should there be concerns around, for example, a person's mental health or other factors which can impede on mental capacity and the ability to consent to or refuse treatment. So as in all health settings, patients must provide informed consent for health interventions or treatments. And when refusal of treatment is potentially high risk, staff will consider whether the patient has capacity to make this decision and ensure that all the information about the treatment risks and benefits is communicated to the patient by as many means as possible to aid their understanding of the issue. And risk assessments are completed, usually within a multidisciplinary meeting, and capacity will be considered as part of this. So using the multidisciplinary team model enables shared expertise and joint decision making for complex cases and ultimately leads to better and safer outcomes for patients. Prisoners do access health services in acute trusts and community services, so it's important for staff in all settings to work together in managing complex cases. Risks escalate further when collaborative working breaks down, and this may be due to a general misunderstanding of healthcare in prisons. For example, an assumption that the prison setting can provide the same care as acute hospitals in the inpatient units. Partnership working is most effective when relationships are established, and acute trusts work alongside prison healthcare and safeguarding colleagues in developing joint care plans for complex patients. And breakdown in collaborative working within prisons can also be an issue. Prison service colleagues are currently not trained around the Mental Capacity Act, and there's no statutory requirement for this to be offered. And this has led to some challenges in effective joint working and has been a barrier in patients accessing appropriate care. And I will go on to describe some examples of this within the case studies at the end. Just to add, I'm currently working with the prison service in the North East to deliver and roll out some training for prison colleagues to enhance their understanding of the Mental Capacity Act. And I'm hopeful that this will have a positive impact on outcomes for patients. At times, there's a challenge around healthcare and custodial perspective. So for us in healthcare, the individual is a patient first and a prisoner second. So our patients can expect the same unbiased patient-centred approach in meeting their health needs as any patient accessing healthcare in the community. Can you move on to the next slide, please, Alex? Thanks. So I'm now just going to talk through two case studies to give some context around some of the challenges in prison healthcare, especially in relation to complex issues involving the Mental Capacity Act and partnership working. So both relate to food refusal. So food refusal can be a form of protest, also referred to as hunger strike, and carried out by individuals with full awareness of the consequences to obtain a specific outcome. However, when this behaviour is a result of an underlying mental health or other condition which impacts on mental capacity, then this would trigger a safeguarding response. Food refusal can be a complex and extremely risky form of self-neglect. These cases were in different prisons and occurred approximately 9 months apart from one another. So both patients were experiencing significant mental health issues. They were receiving care from the mental health teams within the prisons and were experiencing psychosis. They believed that the food, and in one of the cases drinks also, were poisoned and would cause them harm. So both had been assessed by external mental health services for suitability for transfer to secure mental health units and were waiting for beds. As well as concerns for patients who refuse food for a significant length of time, risks escalate if an individual resumes eating, as this can lead to deranged blood electrolytes and cardiac arrest known as refeeding syndrome. So if a patient decides to eat again, depending on certain risk criteria, according to clinical guidelines for best practice, refeeding may need to take place in hospital. So both these patients showed concerning physical signs. One had a history of cardiac issues and the other was already showing some derangement in blood potassium levels, indicative of escalating physical risks. Both had poor engagement with healthcare staff in prison, eventually refusing all physical observations and blood tests, presenting as physically unwell and dehydrated. Multidisciplinary team meetings were convened with the safeguarding team, prison staff, primary care, mental health staff and the GP. Both the patients were assessed as being unable to make decisions around the refusal to eat, the refusal of clinical observations and blood tests, and the refusal to go to hospital for treatment. So best interest decisions were made, and the outcomes for both were that the patients required hospital admission for treatment due to risk of significant harm because of the food refusal. So this is where the cases differed in terms of challenges and how partners were able to work within the Mental Capacity Act. So in the first case, the prison service were part of the best interest discussions, as were the patient's family. The plan was agreed for the patient to be transferred to hospital without his specific consent, if required in his best interest. Admission was planned ahead with communication from the GP in the prison and the acute trust. And once in hospital, the patient was reassessed and deemed to have mental capacity to decline treatment. He was returned to the prison having had a blood test only. So several other hospital admissions were undertaken, which the patient did consent to. And this was challenging for the patient, for the hospital, for the healthcare team in the prison and the operational prison staff due to the complexities in planning patient transfers out of prison. The issue was resolved through strengthened collaboration between the acute trust and the partners in the prison through joint MDTs with a clear joint plan for this patient. So the Trust Mental Capacity Act lead was able to support the mental capacity assessments, which recognised the impact of the patient's psychosis on his ability to make an informed decision to refuse care. And the patient was safely refed in hospital and on return to prison was transferred to a secure mental health unit under the remit of the Mental Health Act to receive appropriate treatment for his condition. And during the best interest meeting in the second case, the prison stated that they were unable to support with a plan to escort the patient to hospital with minimum force required, as they didn't believe this would be lawful. So again, the prison service staff don't receive training around the Mental Capacity Act. They agreed to support the action only if there was a court order in place. So a joint court of protection application was made between prison healthcare and the acute trust. And once this was in place, the prison agreed to support with the transfer. Ultimately, the patient received the care he needed once in hospital, and he was transferred back to the prison to wait for a secure mental health bed. So both these cases demonstrate challenges and complexities of prison healthcare and are certainly not isolated cases. The processes for achieving the best outcomes for these patients were challenging in different ways. Both highlight how issues around mental capacity and mental health, legalities and differences in local interpretations and processes can provide both barriers and opportunities for getting the best outcome for the patient and ultimately impacting on the quality of care for our prison population. Next slide, please. So that brings me to the end of my presentation. I hope I've managed to convey how healthcare in prisons can be complex in different ways to community healthcare, and that this has been a useful snapshot into prison health provision and how our work interfaces with the law. And if anybody does have any further interest in prison healthcare, please reach out to me for more information. So thanks for listening. I'll now hand over to Ben.
Brilliant. Thank you so much, Donna. That was at one level immensely depressing. At another level, it was really important, just in terms of here the kind of granular detail of how you're having to grapple with this. So thank you so much. And last but very much not least of the panel of speakers we've got this evening, Ben Troke. If you don't mind introducing yourself, Ben, and I'll be your tech support slide wise.
Sure, thanks, Alex. So my name's Ben Troke. I'm a partner at Hill Dickinson Solicitors. I am very conscious of my place in the running order. There's a large number of people who've been with us for the best part of 2 hours, and there's already a lot more questions in the box than we're going to have time to deal with. So I will try and keep my bit nice and short and sweet, and allow as much time as we can for that Q&A. I'm going to ignore Ian's failure to manage your expectations earlier when he kept saying Ben's going to explain in detail the case law about medical treatment in the prison context. Clearly, I'm not. With just a few minutes, I am, if I may, just going to make three points, three reflections, if I can. If you wouldn't mind nudging the slide on, please, Alex. 3 points I'm going to make of this. Lots of the key case law about capacity issues plays out in an offender or a prison context. And I'm going to give a couple of examples of that very, very briefly. We're going to talk about why that might be the case, and then I'm just going to wrap up with so what. So some examples of key capacity issues playing out in the offender or prison context. I won't add anything to the explanation of DY earlier. It and a few other cases are very useful for what do we mean by best interests, and in particular, how do we avoid blurring looking at P's own best interests from the forbidden ground of making best interests decisions based on protecting other people and some of the contortions that we find ourselves in. JJ is a case about the question, what do we mean by available options? It's a slightly different context. It's a judicial review judgment from late last year. It involved a patient who was a serving prisoner who was quadriplegic and so disabled that he needed all support for all activities of daily living, including being fed. And he also didn't have a tooth in his head, and so he was at enormously high risk of choking. The case was about his right to be fed food of his choice. In particular, he wanted food which was assessed to have a particularly high risk of choking for him, stuff like boiled sweets and crisps. And the provider of prison healthcare in that case said no. And it was challenged by way of a judicial review, and the court upheld the healthcare provider's refusal, looked at the consequences for the staff if they went against their better judgment and made available things which were particularly high risk. This isn't the world of best interest decision making. JJ was an adult, full mental capacity, able to make his own unwise decisions, but the court looked at the consequences of being unable to make those unwise decisions, the distress even to the most experienced staff of seeing someone choke to death, the consequences there would be of that, potentially going through regulatory, professional regulatory, criminal investigations as a result of a death in those circumstances. The judge gave the analogy of a person able to take their own risks by climbing a mountain, but not necessarily being able to demand that their carer go with them if that's what they want to do. A right to make unwise decisions does not oblige people to offer you unwise options. And it's an interesting question about the extent to which quasi best interests values don't just come at the end of the ability to make the decision, assess capacity, make a best interest decision process, but also perhaps feed in at the front of that cycle in terms of the options that are made available. Going back 20 years before the Mental Capacity Act, what does capacity mean was the subject of a case, Re C, in a prison context. Re C involved a man detained in Broadmoor with a grossly necrotic ulcerous right leg, told he needed an amputation to survive, or he'd have a 15% chance of survival without it. He refused it. I'd rather die with two legs than live with one, was the phrase. His paranoid schizophrenia gave him a delusion he was actually a world-class vascular surgeon himself, and he knew better than the doctors. And the court upheld his refusal of that treatment, applying the test, a three-stage test. Could he comprehend and retain the information relevant to the decision? Could he believe it? Could he weigh it up? And in that, you can see the roots of the variance, the functional test for the Mental Capacity Act purposes 20 years later, about understanding, retaining, weighing up the information relevant to the decision. Why is it that there's so much capacity key case law are playing out in this sort of prisoner or offender context. I think two things. One might be the stuff we've heard about the prevalence of mental health conditions in prisons, but I think the other is that we're dealing with a group of people whose liberty, whose autonomy is already restricted. We're not just talking about Article 5, right to liberty, we're talking about Article 8 issues about right to private and family life. And often we're talking about further restrictions being imposed on people already restricted. I won't go into the facts too much of Dr. A. It was a case in which the inherent jurisdiction was invoked because there was an issue about force feeding as physical healthcare treatment someone who was already detained under the Mental Health Act, and the challenges that brought. The issue of the extent to which we impinge further on the liberty that people are left with, though already detained. The parallel I think of, perhaps the analogy while I was reflecting on this, is the complexity of the clinical negligence claim, say in contrast to a personal injury claim. If you have a careless driver, hits someone, knocks them down, breaks every bone in their body, then you talk about how careless they were and how big a check to write. But the clinical negligence context involves a pre-existing condition, an attempt at treatment, perhaps, and trying to unpick the complex causation issues about the extent to which the treatment would have, should have worked. It's just more complex, and therefore perhaps academically more interesting. But my last point is to not get carried away with the academic interest that comes from looking at capacity type issues in this context, because that loses sight of P, the individual at the heart of it, and the importance of even that residual liberty, impinged or limited as it may already be. It's no less important, maybe more important for that. Maybe there's a scarcity principle about the less autonomy there is, the more value it has to that particular individual. So to go back to the JJ case, this wasn't a judicial review about boiled sweets and crisps. This was a case in which he said, quotes, "The only thing that varies in my life is the taste and experience of food. And being able to eat what I want represents the last shred of my humanity and dignity." It's a case about the limits of personal autonomy. And in fact, I'll finish on an update. We were the solicitors dealing with that case on behalf of the defendant. We've heard today it will be going to the Court of Appeal. Permission to appeal has been granted today. So we will look forward to a Court of Appeal judgment about the limits of autonomy in that context. I'll finish there so we can crack on with the Q&A. Thanks, Alex.
Brilliant. Thank you very much, Ben. That's really important. That JJ case is massively important in terms of reinforcing what little autonomy you have left if you're detained is just as much, if not much more important than for anybody else. The point that the European Court of Human Rights also made it in Munjaz a few years ago. Right. Brilliantly self-directed, by the way, timing wise. We've got 7 minutes for questions. We've got lots of really interesting questions in the chat, in the Q&A box. Apologies in advance to anyone whose questions we're unable to answer, just simply time. I'm going to just try and pick out those ones which I think are the most relevant to the biggest number of people. So 2 people have asked slightly different variants of the same question, which is, what are you meant to do where somebody doesn't understand the terms of an order that someone's proposing to make against them? So a restraining order or a sexual harm prevention order. I mean, I know that very much came up in JB's case, Ian. So I wonder, Ian, do you want to kind of take a stab at that?
So the starting point is that in terms of license conditions, restraining orders, SPOs, all the rest of it, ancillary orders of the criminal court, the expectation has always been that the criminal courts will not impose an ancillary order that the defendant cannot understand. The difficulty is, as Caroline probably knows, is that they do impose restraining orders, they do impose ancillary orders on people that they don't necessarily understand. And for example, somebody coming out of the prison on a license will have license conditions imposed automatically if they understand them or not. So you then get into, well, what do the care and support providers do? What do the local authority or the ICB do? The idea that we've approached in a number of cases is that care and support packages will be put in place to encourage, to explain, to remind individuals what those conditions are. And then their approach is a point, like in DY, as to whether or not you put in place a care package so as to enable that person not to breach the orders. And that's a very difficult thing to do, both conceptually, legally, and practically.
I couldn't agree more. Does anyone else? Mike, I wonder if you had any observation there.
It is a tricky one. This may be one of these areas where there's an element of fudging going on. It's a bit like community treatment orders, where people can be discharged without having capacity, but with having a rough idea, if you like, of these people being discharged on the Mental Health Act. So I can see the value of the sexual harm prevention orders, from my point of view, is that it enables you to put a framework around somebody which is very clearly focused around their offending behaviour, and helps them to learn that there are, that this is not a neutral act. Because often people have come to that, if they're in the care system, they may have come to a kind of adolescence and adulthood where these things have been treated in a way which has been unhelpful and reinforced the behaviour. So I think if you can have, if you have some flexibility about using them, they can be pragmatically a good tool, even if the person doesn't quite have capacity, but they need to have some recognition of the restrictions being related to risky acts and in inverted commas, doing wrong. So yeah, I think you have to think very carefully about them.
Thank you. Caroline, because I suspect many people on this call may not be familiar, do you want to just give an idea, or the question somebody's asked is, how helpful are having liaison and diversion practitioners around at a point when you might be involved? Do you want to just kind of speak briefly to that?
Certainly. They're normally more at court rather than at the magistrates' court, where you have those officers around. At the police station, as I said, it's like a ghost town with experts. If you have those reports, it's brilliant, because they are your tools basically. And as I said, appropriate adults are key if they know the person. But also, unfortunately, and I didn't mention in my slides, but appropriate adults, there's the appropriate adult scheme, which of course is someone that wouldn't know the person directly either. So then you're in difficulty. So you have a random person, you're trying to build a relationship with your client, and so the difficulties of opening up are very often closed. In court, they are brilliant, and they help us out a lot with direction and actually persuading judges or benches in which way they should progress cases. And it takes out the pressure of us cases being adjourned for several weeks in order for reports to be obtained. And sort of they are able to give direction immediately of whether someone, I had a young lad who was really unwell, and he was sectioned immediately as soon as he saw the mental health team at court. So it kind of takes that immediate effect away if it can be. But as I said, they're brilliant in the magistrates' court. But unfortunately, they're not there every day. And that's one of the difficulties that you have. So they sometimes get put over what's called paragraph 5 to a hearing date in which so they can be in attendance. But yeah, in a nutshell, police stations are difficult in any aspects with regards to experts. Yeah,
thank you. So I think this one's really probably Gavin and Jessica, but if anyone else wants to chip in, feel very free. So a really interesting question. If the person's incapacitous has got fluctuating capacity, is that going to rule out doing some kind of restorative justice measure in sentencing?
I feel like Gavin's waiting for me to say something so he can think about his answer while I speak. I think it definitely will have an impact. I think I think if you've got someone that has, I think fluctuating capacity is probably more of a better term. I think there is going to be a lack of restoration, and I think wider rehabilitation as well, because any rehabilitation is inevitably going to focus on that individual rather than rehabilitation maybe of their behaviour. It's only going to focus on kind of what's going on in their mind or their brain, which is of course important. but it doesn't necessarily account for those that they've harmed. And I think we lose the ability to reparate and restore when we're managing someone with fluctuating capacity. I also think it impacts on how much they understand. Obviously, how much they understand of what they've done is a huge part of reforming reoffending behaviour. And if we can't if that can't be achieved, restoration is going to be pretty hard.
Gavin, have you got one word to add to that, bearing in mind it's 7 o'clock?
Yes, you're giving me 20 seconds and we're over. Okay, I suppose one quick point here, and that relates to purposes of sentencing. The sentencing guidelines are very much about somebody's culpability when they committed the offence. And what you're also doing with sentencing is you're looking at suitability of different outcomes and disposals. And I think this is one of these classic situations where you could have somebody who has sort of fluctuating capacity, fluctuating conditions, and at the time you may come to the conclusion when they committed the offence, their culpability was low, but their ability to engage meaningfully with a restorative approach can change. Now, the guideline does sort of make it very clear that somebody's well, yes, somebody's culpability can fluctuate. So I would just agree with Jessica's point that somebody's ability to engage is just vital in this particular context. It was a bit more than 20 seconds, sorry.
It was a big question. So thank you. Thank you so much. I'm going to suggest we draw stumps that now. There were other questions which all would have been fascinating, but everybody on the panel and everybody watching has been extremely attentive, extremely engaged, and we've been here for 2 hours. And I think it's important, not least in things talking about P, offending and deprivation of liberty, that we don't actually confine people. So thank you very, very much. Sorry, it was a terrible joke to end with. Thank you so much to all our speakers. Thank you so much to everyone who engaged with us online. And I know that people watching this afterwards are very likely to have questions. And I hope I'm speaking for all the speakers when I say they would very much welcome questions if you've got questions which follow up. So thank you very much, everybody. I'm going to draw it to a close there.